So I did ask for an attendance to be taken. I'm sure you know we're under strict instructions to take this attendance for the Home Office. So, so I hope you don't mind. No, just your name, just your name. No date of birth, nothing, just your name. Yeah. So, the last time we met, we talked about the functions of company law. So basically, we identified a company in the constellation of companies or legal persons, and then we talked about the functions of the law. And today, we in a sense, build on that by saying a few things about certain constitutive elements of the structure, i.e. the rules that form the fundamental aspects of company law, the rules which create separate legal personality and limited liability, right? Because that's crucial. Remember, the overriding theme so far is that if we're going to do corporate governance, in a legal sense, we need to know the company law foundations of it, and that's really the journey. So today, if you look at your seminar sheet, if I just take you there. So we talk about the concept of corporate status and limited shareholder liability. And they're two different concepts. Sometimes people tend to run them together, and I've tried to say to you that we need to keep them separate, right? And one way I try to remind people of how separate they are is to even take you to history to say, in 1844, what did we have? We had separate legal personality through registration. Then, what happened 10 years later? Limited liability. If they're the same, then why did Parliament have to pass this law? So they're different. And I drew on the work of Crackman to bring attention to the defining characteristics of this, right? When you really think about this, he says that separate legal personality ultimately is a rule that shields the company from claims, right? He calls it an entity shielding rule. It shields the entity. In other words, what he's saying is, this is a property rule. Remember? It's a property rule. Maybe 2 years ago, I was having a conversation with my daughter. I think then she was maybe 9 or 10, I can't remember. 10, yeah. And she said, what is a company? What is a company? And I'm thinking, how do you explain this? And I just said, something that owns something, right? In other words, it's the focus on the property aspect. And that's important because it clarifies thinking. It also, remember I told you again, it was relevant in the context of some case that was about to start where there was a report of it in the FT not too long ago. So it had to do with whether a federal republic is the same thing as the federal government. I think I mentioned that. Yeah. Big issue, right? And nobody ever thought this was ever anything, because a depository agreement was entered into by the federal government, and you know, it was signed by the federal government of blah, blah, blah. And when it came to then going to court, it was the Federal Republic of blah, 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 the same, right? And then you get the lawyers, I think Freshfields are on the other side, basically saying, well, they're two different people. And here I'm asking, so I have to do a legal opinion on this, and my point was that at the end of the day, we need to focus on the property aspect. That is, to say something is a person, we're focusing on property, your ability to hold property. And once you apply that test, it therefore means that the government cannot hold property in its own right outside the republic. You see, the government could not own a dime outside the state. Don't confuse the administration with the government, right? You have three layers. You have the administration, the people who get elected. You have the government, which is a constitutional organ. It's as permanent as the state. And then you have the state. The state can't do anything. It has no hands, right? Like the company, you know, right? So if you then say, well, is the government a legal person? Is the government a legal person? I say, well, can the government own property in its own rights? And if the answer to that is no, outside the state, then I think that clarifies things. So these ideas are relevant as we go along, and I thought to sort of flag them up. Now, the other thing I'd like to just do here is just draw your attention to these points. So notice here, I say that we're trying to understand an aspect of the hardware, the constitutive rules of company law, and here we're focusing on separate legal personality, right, and limited liability, hence the map, right? And I say basically they're functions 1 and 2. And if we go to the map, you'd see these two functions, 1 and 2, right? So basically, one is entity shielding, which basically shields the assets, and you see a range of cases dealing with this. In fact, let's think about this. You read Petrodel, right? The case of the wife, right, who wants those assets. What was in operation was an entity shielding rule, right? The husband is saying, you know, it's not personal. Those assets, those houses you want, are locked in their company. They're shielded from me. They're shielded from my creditors. And therefore, you can't go to court, to the matrimonial courts, and convince some family court judge who does not know any company law and get some kind of ancillary relief, right? Because if you do this, you'll be making nonsense of the company, right? But on the other hand, you see the Supreme Court being mindful of this, but also understanding the inherent claims to justice of the wife and finding a way around it, right? And you saw what they did. They used the trust to find a way around it. That way, there was peace. Company lawyers did not go up in arms. That life as we know it will stop because somehow separate legal personality has been undermined. You see assumption saying, this is not an attack on separate legal personality, right? And at the same time, the people who tune into Women's Hour is a radio program, Radio 4, where they discuss issues to do with women, because they were following this case, and the Daily Mail, you know, they were really following it, because if this case were decided the other way, it would affect the rights of people who are married. So they were also very happy that some solution was found. And so what you're seeing here in the story is the pressure from the noise outside to disrupt the architecture of the law. There's always noise outside. And if the noise is too loud, then it could affect the building blocks of the law. And you see the Supreme Court basically resisting this. Now, on the other hand, in the area of tort, there's been a lot of noise. If you look at the asbestos cases, Adams and Cape, down to Lungowi, and even the Okabi case involving Shell. Again, I was involved in that case because it was brought by a firm here who do a lot of public interest litigation. So, and what had happened in the Shell case was the first one resulted in a settlement. Basically, this had to do with pipelines, right? Oil pipelines, which had not been maintained. And those oil pipelines were vandalized by the local community to get fuel. And every now and then you get a fire. And so the litigation was brought by the community. So they got the lawyers here to bring this case against Shell. And the argument was that Shell had a duty to safeguard those pipelines. Literally, the argument was that Shell should have policed them, right, to prevent people from vandalizing it. But the most important thing is that the case was against the parent company here. Now, the parent company, well, there are two companies, the SPDC, that's Shell Petroleum Development Corporation, and the one here. Now, at the first level, so the first iteration of this case, we were able to get a settlement. And that settlement came to over $80 million, the largest ever paid by Shell to a community. So, but it was paid by SPDC, the local company, right? They settled because they had deep pockets. And but there were some other claims, which is the Opabi one, which I'm mentioning. And so here they go against the parent company, right? And because there's lots of money. Shell then says, we're not going to settle this, we're going to fight it. And they fight it, right? They prevent the use of tort law the use of tort law to undermine settled legal principles, right? And that's kind of similar to what we see with Petrodel, right? The point I'm making, ultimately, is that the orthodox position is separate legal personality, right? That's the orthodox position, and we're going to see this in a range of cases. And every now and then, the pressure from outside becomes so loud that you get this challenge to orthodox principles. And I think the greatest source today is through tort law, right? Because the beauty of tort law, just like trust, is that, we would say we're not assaulting separate legal personality. We're not damaging anything, right? That's the beauty of tort law, to say that, all we're saying is, yes, we accept the company as a separate person, but we also know that somebody else, right, a separate person, is involved, right? So we're not lifting the veil. We're not piercing the veil. We're simply recognizing, right, that somebody else is involved. If you look at cases like Jones and Lipman, Guilford Motors and Horn, right, on the seminar sheet, these are cases where common lawyers in the past used to talk about piercing the veil. I remember one of my early articles, which I never bothered to put on your reading list. I argued that this is not about veil piercing. It was so clear to me then, as daylight follows darkness. This is so clear. This is not about veil piercing. This is about recognizing the company as a separate person. Because we recognize the company as a separate person, take, say, Jones and Lippman, or Guilford Motors and Horn, where you use a company to evade rights. So using the facts of one, somebody enters into a contract, right, to convey property, right? So you enter into a contract to convey property. And then, because you do not want to convey that property, what do? You transfer the property to your company, right? Then the court then comes and says, well, we will disregard this transfer. This is a conveyance. It's a fraudulent conveyance to defeat the claims of somebody. And then come the lawyers right and say, hey, this is about veil piercing. There's no veil piercing here. If two human beings did the same thing, the courts would do the same thing. Right? If I transfer property to a cousin, the courts are not going to be, they're not going to sort of become blind. They're going to realize the realities of what's going on, right, isn't it? So my point is that we don't need to call it veil piercing. This is just simply the recognition of what people do and therefore what companies do. So if I go back to this. So I mentioned here two reasons why I was talking about those cases, and so there's a second reason I'm focusing on now, and I said the second reason. So there's a typo there which I should correct. The second reason has to do with the extent to which other significant actors, let's just pause there. Company law has always been about, I suppose shareholders, right? But one thing we did say is that we've got to recognize that there are other significant actors. And if we kind of go, sorry, I hope you guys don't sort of go dizzy with this. So notice here, the function of company law, I said there's a fifth one, right? I said facilitating the bargains of the Trinity, right? And other significant actors. So these are people outside the Trinity, and what are they, right? So the first aspect clearly of the Trinity will be the members of the company who come together by contract, right? They announce their union by contract, right? Should I say not their union, their association. In fact, not even the association. They come together just through a contract, right? Because remember what the Supreme Court of the United States did in the Citizens case that we mentioned, that I said we need to break out of this idea that at the heart of the company is a contractual association of people, right? We know it's contract, but it's not essential to the formation of the company because one person can form a company, right? So, and now here you may think it's no big deal, but in America it's a big deal because if you go down that route of an association of persons, then you trigger Second Amendment rights, free speech for companies, and therefore campaign finance, and therefore Republican Party gets more money, blah blah blah, and all, and the Democrats are not very happy with this. So there it's a big deal. Here it's not too much of a big deal. It's a jurisprudential point, right? Okay. So we have the members, and then we have the directors. The directors are not bound by this contract, right? I don't need to be a shareholder to be a director, right? But it'll be ridiculous to wish me out of the equation. I'm part of it. Hence, my use of the term, the Trinity, to bring them in. And then the third aspect would be creditors, right? Because creditors have creditors have contracts with the company, but not in the company. They have contracts that give them rights against the company, but not rights in the company. But you may say, well, that's neither here nor there, because these creditors are able to bargain for rights that can be even stronger than the rights of shareholders, right? So if you look at the bond agreement and you look at all the triggers and the rights it gives creditors, in some cases people would say that creditors actually have a stronger role to play in corporate governance. There's an article that goes, creditors, the missing lever of corporate governance. It's a tool that could be used for corporate governance. But anyway, I just thought to mention this. So, and who are these significant actors? We've talked about them. How does the law recognize them? So if you look at Section 172, which basically talks about the duty of directors, right? It says, we'll come to Section 172 in a minute, but not in a minute, maybe 7 minutes later. But the point is, Section 172 is the core duty of loyalty, right? It says to directors, you need to promote the success of the company, be loyal, and consider a range of other interests. Hence the idea of stakeholder interests, stakeholders. So the stakeholders go beyond the members of the company. This is the point I'm making. Section 172, which enshrines the enlightened shareholder model in our company law, basically mandates you to consider stakeholders whilst promoting the success of a company for the benefit of the shareholders, right? So if that is the case, we come back here where I say that we're concerned, right, the extent to which other significant actors connected to the registered company. So what I have in mind here are creditors. Think about Adams and Cape, those involuntary creditors. I get damaged by asbestos. Think about Lungowe. Think about, the community in the Shell case, right? These are involuntary creditors. They didn't enter into an agreement to become creditors, right? They're just, like many things in life, they suffer the misfortune of geography. I've always believed that many problems in the world are due to geography. But anyway, I digress. So it says these other significant actors connected registered company are prejudiced by the operation of this rule. So I'm not saying should be, so please cancel that. So the second reason has to do with the extent to which other significant actors connected to the registered company are prejudiced by the operation of the fundamental rule of separate legal personality. It should not be should be prejudiced. I'm sure that the smart ones around you must have known that was a typo. They are prejudiced, right? It's not a function of company law to prejudice them, but we know that as a result of these rules, then some people get prejudiced, right? And if they get, because separate legal personality, limited liability, have the effect of, at least together, of shifting risk to unsecured creditors. And the question then is, what do we do about it? So I said another way of putting it is this: should company law move from its doctrinaire position by recognizing the interests of stakeholders who may suffer as a result of the activities of a parent company with whom they had no direct dealings? Should company law embrace this? Now, a lot of people who talk about corporate governance, a lot of people who, when I did this, the Shell case, I remember one way in court, because I remember I told you, I said it led to a settlement, so not a judgment, right? So when we were in court, there are lots of NGOs, right, all coming to interview folks. And you could see that the NGOs, for them, the companies are obviously the bad guys, right? They're always the bad guys, and, they're like the paragons of virtue. Life is so simple. And for them, this is corporate governance. That's the picture of corporate governance they see. Do you understand? For them, when they talk about corporate governance, they're talking about globalization. They're talking about big corporations, taking advantage of countries, of people. They're not thinking about other aspects of corporate governance. And my point basically is that in this course, we need to be able to think about everything, especially if we're going to be given legal advice. So I thought I'll just flag this point up and then ask you what you think about the questions that you no doubt would have been reflecting on. So I think the first question by now should be pretty straightforward. Does corporate status, which is separate legal personality, does this denote limited liability? And I think by now the answer is no, it's clear. Right? So we're not going to waste time on that. So what do you think Salomon's case decided? You would have read Salomon's case. What exactly did it decide?
Company is not a fiction.
Yeah.
An entity.
Yeah. That's yeah. Okay. So that's what you think Salomon decided?
Yeah, basically.
Yeah, basically. Okay. But somebody could say, well, The 1844 Act told us that. Solomon was decided in 1897. It didn't tell. Did Solomon really tell us what the 1844 Act told us? That with registration, there is this persona ficta? Do you think that's all? Do you think that's what the judges did?
He told us that he's a legal person, irrespective of the motives of the shareholders who incorporated that company.
Yeah, yeah.
Once it's duly registered.
Yes. So in a sense, that's and by the way, would you say that is relevant today? That point, is it relevant?
I would say so.
Okay. So because in a sense, it's a point about statutory interpretation, isn't it? So there are two ways you could answer that question. The old act, which was before the law lords in that case, basically said, that when 7 people come together and, subscribe their names to this memorandum, then they form a company, right? And the law is not interested in whether there are 6 dummies and 1 main guy, right? And that's the context in which the court is saying motive is irrelevant. But I would say, today we could say that's just a statutory interpretation point. It's not relevant. The law now today allows for 1 person to form a company, right? The law allows 1 person to form a company, so we don't even need to go down, the reasons why 7 people come together, right? So you could say that. But there's another way we could also ask the same question. We could say that if you say motive is irrelevant, what if we form a company to do bad things, right? Now, okay, let me even qualify that, because I don't want to get all moralistic here. So maybe not bad things, because who's to say it's bad? I mean, the state says some things are bad, right? So we'll agree that some things are bad, right, according to the state. But let's say...
Shell company.
Sorry?
Shell company.
A shell company. Again, that's interesting. I'll come to that. I have all these stories to tell. Each time you say there's a shell company, I have the story, but I don't want to be the guy who tells too many stories. But anyway, a shell company is not a bad thing, is it? How can it be a bad thing? It had a lot to do with this story I'm not going to say, where I had to defend. Somebody basically said, "Oh, it's a shell company." I said, in fact, they made 2 points. A shell company bought off the shelf. And I said, and so what? We live in a world where companies have been commodified. That's it. You just buy it off the shelf. And, and what's wrong with a shell company? It's a normal, if you're going to do a transaction, it makes sense for every transaction you do, like let's say it's a takeover, to use a subsidiary, not to, right? Because you need entity shielding. Entity shielding. So that's it. That's not what I have in mind. So let's imagine somebody, and I'm not going to be original here, so lest you ascribe motives to me in trying to explicate this whole idea of motives. So this lady sets up a company called Personal Services Limited, and I think the Attorney General was not happy with the name. I think she then changed the French Lessons Limited, to engage in the business of a personal nature, to bring delights to people. And the government, the Attorney General, basically says, no, we're not going to let this company be set up. So he goes to court. And the question is, we know that prostitution is not illegal, right? Certainly in this jurisdiction, it's not illegal. So if it's not illegal, I mean, there are surrounding offenses, like, cab crawling, that kind of stuff, but the act itself is not illegal. So if it's not illegal, then in light of the fact that in 1844, Gladstone democratized the right to form a company, right? Everybody had this right, and it was automatic. It's no longer a concession of the state, right? It just happened. Then, on what basis could we say that the Attorney General is entitled to stop this company from being formed? What do you think? Because that goes to motive. You said motive is no longer relevant. Here the Attorney General will be saying motive is irrelevant. It's relevant. Look at the motive. It's clear. It's stated there that they are going to do this. And we do not want the state to allow this company to be formed.
Wrongful trading, fraudulent trading.
You think that's wrongful trading?
It's a shame.
I mean, like a facade. I mean, I know the company will not give the massage, but you know, but I mean, I don't think if you call it a. Sorry. Okay, just to be clear, we're on the same page, right? Here's a company, right? And the company has a business. The business is not prohibited by the criminal law, right? And the lady is saying, I have a right to form this company. Now, you are the lawyer. Does she have a right to form this company? What do you think? Any ideas? Yeah, please.
I think if it's not prohibited by law, then of course she can form a company.
Yeah. But the slight problem, though, is that although it's not contrary to the criminal law, okay, let me test it this way. If this company was carrying on business, and I suppose if they were selling bags of rice or whatever, and somebody took the rice and did not pay, you could sue. Do you think the CEO could sue for the fees of the company if a client refused to pay? Would there be a claim in court?
Well, it depends on the countries. I don't know how it is in the
No,
UK,
yeah,
but
okay,
there's
yeah.
countries which are like where prostitution is not prohibited, but only the lady performing the act could claim the money, and only afterwards.
Yeah.
But some other countries allow it, and some others say like.
Super. Yeah.
It's not a criminal offense, but there's no possibility like to claim for anything.
In the civil law.
Yes.
Exactly. And I mean, you put your finger on it. Obviously it's a jurisdictional issue, but you put your finger on it, which is this: that the fact that an act is not criminal is not the end of the story. If it is civilly unenforceable, if it implicates civil illegality, right, then the courts are basically saying this is not for a lawful purpose. So when you look at the law, which talks about the formation of a company, it says to set up a company for a lawful purpose, right, for a lawful purpose. So, and the idea now is that, well, this is not a lawful purpose. Even though it's not criminal, it's not a lawful purpose. And therefore, the state will not grant you the right to form a company. So even though we say, so see the journey so far, we're making a number of points, that previously the right to form a company was not democratized. You had no right to it. But by 1844, it became freely available. Everybody could form a company through registration. However, there is a limit, and that limit is that it should not be for an unlawful purpose. And to use the term lawful purpose here, we're thinking not just about the criminal law side, but also under the civil law. Right, okay. And if that's the case, then I suppose we've already answered that question I posed, which generated this. What does Solomon really decide? So he said, it talks about the motive not being relevant, right? We kind of dealt with that. But so if that's the case, then Solomon is not relevant today. If Solomon is simply a case on statutory interpretation, then why should we read Solomon today? Do you understand? If the big deal of Solomon's case is statutory interpretation, which no longer applies, right, because we now know, then what's the point of reading Solomon? What's the point? Now, isn't that a clue to you that I think that Solomon actually has something else to tell us? Perhaps something bigger than something bigger than statutory interpretation.
I think the fact is that the ultimate fact is that the company doesn't act as an agent of Solomon. We are two different entities.
Yeah.
Solomon.
Yes, precisely. So that's you're there. So basically, and this would be the way to spin it, isn't it? To say that what Solomon really decided is that the rule of separate legal personality, entity shielding, is so fundamental that we will not allow it to be eroded, right? We will not allow it to be eroded. And this principle is a rule, can be stated this way, it's a rule against veil piercing. Solomon's case established a rule against veil piercing. You know, a veil, right? We do not pierce it. It's better to look at it this way. If you don't look at it this way, we get confused. A lot of people, when they, when people study company law, maybe it's the way the textbooks are arranged. So after a separate legal personality, they talk about lifting the veil, as if it should happen, lifting the veil. So you see these guys, they're transaction law. Well, they shouldn't really be good transaction lawyers, and they're very quick to think about lifting the veil. Now, I see things differently. I see things in a way where we need to respect the veil, right? So I don't say to myself automatically, we must lift the veil, right? So if I were writing a textbook, I wouldn't sort of have a chapter called Lifting the Veil. The chapter would be the rule against lifting the veil, the rule against piercing the veil, right? This is important because this is what Solomon basically said, right? And to build on so you dealt with the detail. So Solomon is saying, we will not allow you use arguments of agency, right, to undermine the veil, right? So in other words, to say, well, the shareholder has 100 shares, and the company share capital is divided into 100 shares, and therefore the shareholder controls the company, and therefore there's an agency relationship, right? Those arguments have been dismissed. If you look at cases like Gramophone and Stanley, beginning with Solomon's case, you see those arguments are given short shrift. We will not use agency, right, to undermine separate legal personality. So I would say, just to bring it together, that first rule, constitutive rule of company law, separate legal personality, is so important. It's so important that in 1897, the courts were basically establishing another rule. They didn't need to establish a rule on that one because we already knew it existed in 1844. So they were establishing another rule to protect that first rule. And what's the rule? The rule against veil piercing. And so important is that rule that when the Supreme Court was deciding Petrodel, they had to respect it, right? They had to respect. In fact, it got to a point where the Supreme Court said, Assumption said, Neuberger said that I really wonder whether there is even a doctrine known as piercing the veil. Did you get that bit? Did you read that bit where he says, I even wonder whether there is a doctrine known as piercing the veil? Now, that would be too radical, right? So they kind of agreed, okay, maybe there is such a doctrine, but we don't know how. Because every other case we can explain, right? We can explain every case, that, so including Petrodel, obviously, because Petrodel was not about piercing the veil, even though they achieved what they wanted to achieve. So when he said that, I even wonder, that tells you, that's confirmation of this point. And so if we just go back to Petrodel, after Petrodel, we'll take a break, right? So something to look forward to, right? There will be release, okay. Okay, so remember, we're talking about entity shielding here, and I'm talking about how this creates some problems and how common law tries to solve it. So basically, one problem it creates, right, is to third parties, right? The third parties could be contractual third parties or third parties who have not contracted with you, right? Involuntary creditors, right? Because, the use of the company could create problems, right? And there are ways this could manifest. Improper use of the company affecting third parties, right? So look at the case where I have a contract to transfer land to somebody, and then I refuse to honor the contract. So what do? I transfer the land to the company. So I'm using a company, right, as a device to evade my legal obligations, thereby inflicting a loss on a third party. That is what happened in cases like Jones and Lipman, Guilford Motors, and Horn. So then we now get the piercing the veil. But before we think about piercing the veil, we have to remember that the rule is a rule against piercing the veil. All right? What does that just mean? It's a pause for thought. It's a pause for thought. We stop, we think, we reflect that, what we're going to do now is really, why is this thing shaking? It's always shaking. But anyway, so what we're going to do is so serious, we've got to be careful before we take a knife and start cutting up company law principles. Right? So let's look at Petrodel. This is the Petrodel case. So what I've just done here is break the reasoning down, right? So this is how loss assumption, can you see it? Can you read it? Okay. So it says there is a broad principle that the corporate veil may be pierced. So remember, I said Neuberger said, I wonder whether. Assumption is saying there is a broad principle, right? May be pierced to prevent the abuse of corporate legal personality. Then he says, it may be an abuse of separate legal personality to use it to evade the law or to frustrate its enforcement. And it says that there is a limited principle in English law which applies when a person is under an existing legal obligation, right, which he deliberately evades by interposing a company under his control, just like the case I mentioned when you transfer property to a company. Then he says the court may then pierce the veil, right? He calls this the evasion principle. The evasion principle. Now, on the other hand, when you're trying to find out what's going on in a company, you just want information, then, that's different. So here he says, this is distinct from the concealment principle where the court is not disregarding the facade, but only looking to it to discover facts. So basically, under the concealment principle, things which would otherwise be outside the range of judicial vision are now captured. They're now within the radar. You can see. But you're not undermining anything. You simply have X-ray specs. Right? Do they still do X-ray specs? I remember when I was growing up, as a 13-year-old, you read Marvel comics and X-ray specs, and you order them. And, but anyway, I don't know. I've not seen them ever since. So that's what the court is doing. They're not doing anything other than that. Now, he then says, number 4, he says the principle is probably described as a limited one. Notice this, limited one. Neuberger says he wonders whether the principle even exists. Now this guy is saying it's limited, right? Because in almost every case where the test is satisfied, the facts will in practice disclose a legal relationship between the company and the controller, which will make it unnecessary to pierce the veil. Remember the example I gave when I said that when I was writing about Jones and Littman, I kept on thinking, but this is not about veil piercing. We would do the same thing with human beings, right? We will be able to explain it. I mean, if we're writing about human beings, we're not going to talk about veil piercing. We'll simply say, oh, there's been a fraudulent conveyance, and all that. So this is why he's saying, because we can explain it. And later you're going to see Neuberger say, I wonder whether it does exist. And then he says, the piercing of the corporate veil cannot be justified in this case by reference to any general principle of law. So this is respect for separate legal personality. And he then says that it follows from the above analysis that the only basis on which the companies can be ordered to convey the 7 disputed properties to the wife is that trust law allows us to do this. In other words, he's saying that the husband actually is the beneficial owner of the properties. The problem with this way of doing it, right, is that this would create problems in a different context. Say, imagine if my company goes bust, and so there's some money in the account. Then I say that money was held for me on a trust. You see? Then you deprive the creditors of the money. Because you think about it, what the judge is doing here, ultimately, is depriving the creditors of Petrodel by using the trust. You're basically saying, these 7 properties, rather than give the creditors of the company, we will give it to the wife. Well, you've made a choice. And I think you've set the scene for anyone to use this device. Obviously, it will be a matter of evidence, but bear that in mind. Now, look at Lord Neuberger, and then you'd go for this break. So he says, I also agree that cases concerned with concealment do not involve piercing the veil at all, right? Right. So, but remember, we're not dealing with concealment. Then he says, I agree that if the court has power to pierce the veil, Montbéliard was correct to suggest that it could only do so in favor of a party when all other more conventional remedies prove to be of no assistance. So in other words, if piercing actually does exist as a legal category, it must be because we can't explain it with the other ones, right? Agency and such like. Then he says any discussion must begin with a decision in Solomon. And he says, it does not appear to me that the facts, so he says, it does not appear to me that the facts and outcome in Guilford Motors and Jones provide much direct support for the doctrine. So he's saying this doctrine about piercing the veil, that he doesn't see support. And he goes on to explain those cases. So he says further, they indicate that where a court is of the view that there is no other method of achieving justice, the doctrine provides a valuable means of doing so. So you see his doubts, right? But the bottom line here is there is fundamental respect, right, for separate legal personality. It's no mere rule. It's no mere rule. If you know, when I look at systems that do not respect separate legal personality, it says a lot about how those systems operate in terms of the creation of wealth. You know, when you do complicated financial transactions, you have to be able to rely on those structures standing, right? If you're thinking about it like a securitization, and you have an SPV and all that, you really want your judiciary to understand what you're doing. And in societies that are not very great when it comes to wealth making, It is largely because of things like this. So contracts are not enforced. You don't really understand promises. If you ride roughshod over these things, poverty is the result. No argument about this. It's not by mistake. Some societies make money, and other societies are poor. It's not by accident. So the point I'm making, I know you wonder why separate legal personality is key. I think it's really key. I did say last time, sometime we met, I said I wonder whether the company, apart from the discovery of agriculture, I wonder whether the company is probably the next best thing human beings have done. It's a fantastic wealth creation machine, but it can only work to the extent that these set of rules are respected. So let's take this 10-minute break, and we'll come back and continue. If you've not put your name on the list, could you kindly do so? Yeah. Okay. Okay. Thank you. Yeah. So what I just want to do now is just quickly go through some of the points on the seminar sheet. So you see corporate status being referred to in Section 16 of the Companies Act. I hope by now you have your Companies Act, right? So you familiarize yourself, right? Please, if you've not looked at it, do look at it. The case next to that is the case I actually referred to. The Attorney General's reference is the case I mentioned in regard to the French lessons. Sorry, it's the lady who used it, not me, in that particular case. Remember the case involving the Attorney General, who basically says you can't set up a business for this purpose. It's not a lawful purpose. And that kind of ties into Section 16, right? So Section 16, the whole idea of the state registering a company and therefore it having life, corporate status, it has to be for a lawful purpose. So that's the Attorney General's reference case. Then you have the, under the heading, some implications of separate legal personality. So here we are just playing around with this idea of separate legal personality. So let's take one of them you already know. The other, the case here, the Attorney General reference number 2, deals with a slightly different point. And again, I remember I had raised this in class before, where I said that can somebody be convicted of theft from taking money from his company when he owns all the shares, right? In that case, the Attorney General goes to court to clarify this. And the court says, of course, it's a different person. And if there is an appropriation of property, right, and it's wrongful, then it's theft, right? And of course, we know that creditors will be affected anyway, right? If the company goes into insolvency, the creditors are affected. So that's an implication. Then force and habital. Force and habital. Notice this. Notice that this case was decided in 1843. In other words, it was decided 1 year before corporate status came about. So why are we studying it? Why? Because the Victoria Park Company had corporate status through some other means. Remember I said before the 1844 Act, whereby you got corporate status through registration, you could be a chartered company or you could be a statutory company. The Victoria Park Company was a statutory company. So there was corporate status, right? And the idea here, what had happened here was that some shareholders accused the directors of waste. They basically said the directors had been inept, had committed breaches of directors' duties, and they tried to go to court. And then the court said, but wait a minute, if the company is a separate person with its own rights and obligations, then if the directors have harmed the company through their actions, then it's for the company to sue, not you, because the company is a person, right? So in other words, you need to keep in mind that the company, if the company is a person, then you and I have no business suing on behalf of the company. The same way, if your neighbor is harmed, it's not for you to, in a sense, vindicate his rights. There's a saying in a book I read a long time ago called Things Fall Apart, where it says that the neighbor whipping more than the bereaved. the neighbor whipping more than the bereaved, you know. You can't care too much, right? So here, the idea is that if the company is the victim, the company should be the one to sue, not you. And this idea decided, that was formulated or clarified in 1843, is central to our company law, to the whole business of minority shareholder protection. Because what about a situation where the directors have breached their duties and it has cost you loss? Right? It has cost you loss. I'll give you an example. I don't know how many of you watch Dragon's Den. You watch Dragon's Den? It's on terrestrial television. And I know it's been franchised around, you know. But I guess if they ask, do you watch X Factor, you would say yes. Anyway, Dragon's Den is this program where you go into the den where there are dragons in the form of nice-looking human beings who have lots of money. You pitch an idea to them, and then they decide whether or not they back you, whether they fund it, right? And so one of the stars of the Dragon's Den is a guy called Theo Perfitis, right? There's a company on the market called Ryman's. You buy stationery from Ryman's. You know. Theo Perfitis is like one of the main guys behind Ryman's, right? So he's a darling of the city, and apparently they were also in the lingerie business. And so what happened was that La Senza had come into the market and said, you know, we want to like sell our business, right? So they go to Theo Perfitis' company, which is in the lingerie business, and Theo, who is the director, should take that opportunity for the company, right? Because that's his business. So what does he do? He takes the opportunity for his private company, where his wife, himself, and his kids have an interest. Not for the company. And then, but his private company does not have the money to fund it, or at least maybe they do have the money, but he's not willing to spend their own money. So what does he do? He goes to the company of which he's director to get money from that company to do it. Talk about adding insult to injury, putting salt on a wound. And so he does this. And then a shareholder is not happy. So the shareholder raises a corporate governance issue. There's a corporate governance issue, which kind of is also a company law issue, so they coincide. So he's saying, Theo, I thought this was our company's deal, but you've taken it. And he says, well, I'm going to go to court to sue. Now, do you think we should give this guy justice? Because now remember, his share, the value of the shares in his pocket is not at the level it would have been had they taken on this deal. Because, by the way, Theo, runs this La Senza business so well, and then later sells it to a venture capitalist fund, and makes tons of money, right? And continues to be the star in the Dragon's Den, right? So the question I ask now is, what do we say to this guy, the guy who has suffered? Do we say to him, let's sue? What do you think? And let me remind you, whatever you do, do not assault separate legal personality. Do not destroy that principle, because we've spent the whole morning talking about this. So be careful. Separate legal personality has to be protected, right? And just in case you want to forget, remember 1843, Force and Habertal. They went and accused the directors of waste. And you know what the court said. So what do we do in this case? Remember also, the value of the shares in your pocket have suffered. They've suffered a diminution in value. So you've lost money. And Theo is living large on his yacht. What do we do? What do you do?
The company would have to sue.
Sorry?
So it's the company who would have to sue?
The company would have to sue. Yes. the company would have to sue because you're being faithful to separate legal personality. They're saying the company has rights and obligations, and if the company suffers, your loss is simply a reflection of the company's loss. It's simply a mirror, isn't it? So the company should sue. The problem is that the company here is controlled by Theo. So how are we going to get around this? How do we convince Theo to commit suicide financially? How do we, do this? How are you going to convince him? What do you do? Yeah.
Maybe in this case the shareholder could sue on behalf of the company.
Yes, the shareholder, yeah.
Represents the company instead of the director.
Yes. So basically the shareholder should sue on behalf of the company. So that means you are assaulted separate legal personality. Right? You're assaulted separate. Let's call it what it is, isn't it? Yeah, but the point is that we can do this, right? Because we're mindful of what we're doing, right? So we've had that pause for thought, and we're mindful. And how are we doing this? We're doing this because statute allows us to do it through a derivative action. A derivative action, right? So you say that this action I'm going to bring, it's the company's action. It's not my action, it's the company. It derives from the company, right? And I swear, right, or my whatever, that whatever damages I get goes to the company. Right? It goes to the company. So the court there then has to decide, should we permit an override? Because that's really what they have to do, right? Should we permit an override and allow you sue on behalf of the company? Right? And the question the court really ultimately would really have to decide is this. Has there been governance failure? Why has the board not brought this action against Theo? Right? The company's board. Why has it? So has there been a corporate governance failure? You see, has there been a corporate governance failure that prevents the board from bringing this action against Theo? Now, guess what? That's as far as company law takes it. Corporate governance would say, well, there should be an independent committee of the board. Do you see? So if you do things properly, there will be an independent committee of the board that would look into this and then decide whether or not to sue Theo. Because you know something, there are times in life when you just have to lick your wounds. It's not every time you go to war, right? Wisdom is needed here. It's not every time, just because there's a cause of action, you must sue. Right? What if Theo is the guy with the magic touch? Right? The guy who makes things happen. I mean, look at the stuff Elon Musk is doing in Tesla. Right? We allow him to get away with it. Right? Because, he's great. Right? And the only thing the SEC did recently was to come up. By the way, I don't know if you noticed, when the SEC came up with this ruling that Elon Musk should no longer be the chairman and CEO of the company. What the SEC, and just to give you some background in case some people don't know what's going on, Elon Musk, the head of Tesla, whiz kid, he basically puts out a tweet saying that the Saudis are going to give him money for him to buy the company and take it private. And nothing like that happened. I think apparently there was a bet, and he just sort of maybe had some weed, right? And because subsequently was smoking weed on television or on radio, whatever. I can't remember.
You also announced the prices.
Yeah, exactly, and all that. So the SEC gets involved to say, well, is this true? And all that. So clearly nothing like that had happened. So that's misleading the market, right? So, people go to jail for this. So, but what the SEC did was to say, well, we're going to reach a settlement with you. A, you're going to pay compensation, and B, no longer be the chairman. What they did, right, and that's something we're noticing today, with regulators. Regulators are using regulatory power to make corporate governance changes to companies. In this case, it's the SEC, right? And this idea of splitting chairman and CEO, where do you think it came from? Here, the UK. It came from the Cadbury Code, right? The whole idea of splitting that role, and came from this, and now you see this being applied there, and it's really interesting when you sort of reflect how regulators are using regulatory power to implement corporate governance changes. A typical example would be a company which has been investigated for corruption, right? So the company then, so what tends to happen is that the company would enter into a deal with the prosecutors, some kind of settlement to say, okay, you know what, one do this, one do that, and be good boys. And what tends to happen now is that the prosecutors would then use that opportunity. You never let a crisis go to waste, right? So they use that opportunity to implement corporate governance changes in those companies. So they'll say, oh, we need you to have this kind of committee, we need you to do this, we need you to do that. And that's interesting because the company does not need to be a premium listed company. This is the point. The company, if the company is a premium listed company, it has to apply the code on corporate governance. But this company may not be a premium listed company, and some unelected bureaucrat somewhere, sits down and says, you know what, I have certain values in life, right, which may be in addition to whatever is in the code of corporate governance. And, my values I'm going to inflict on the company. And by the way, they will agree, because that's going to be part of the settlement. So there is an issue about democracy, right, accountability, right? But that's a separate issue for those thinking about essays and all that. But, think about the accountability of government officials in pushing corporate governance ideas as mandates, as private mandates to companies. And the example of Elon Musk is one, right? So force and habital, because I just want us to connect everything together. Some people are looking really tired, and maybe my caffeine is working for me. So, you look tired or bored. So, remember where we're coming from now. We're saying separate legal personality, 1844. Force and habital took the same idea, right? Because separate legal personality was already there, and it remains faithful to it, and it therefore means that we need to think about this at every point. We need to think about the company as a separate person. It's really important in whichever way it comes, right? So it may come up at the level of a transaction or in litigation. Always remember that the company is separate. But also remember that company law has always provided ways you can get around the rules, right? Because remember, I said to you some time ago that company law could have easily given us two sections: separate legal personality, limited liability, case closed. But instead, we have over 1,000 sections. The reason why we have over 1,000 sections is to respond to these problems. So in this case, we now know how to go around it. And as you said, in this kind of example, we will bring a derivative action, right? We'll bring a derivative action. And sometimes, you've got to kind of think, why did the board not bring this action? Why did the board not sue the directors? I'm referring now to the Theo Pafitas case, right? The guy who took the La Senza deal. Why did the board not do this? Because before you bring a derivative action, you need to be able to convince the court that there has been governance failure of such a magnitude that we should override them and not respect separate legal personality, right? So it's not very easy to do. Now, for you to do that, you really have to show that these directors really had no clue. Now, and I was then saying that there are many reasons why we may choose not to sue Theo Paphitis, right? And I said, okay, he may be an Elon Musk type character, and then I digressed. I'll come back. Well, another reason could be that, you know, it may not make any commercial sense. So in this case, you will sue the director, ask him to give an account of his profits, and then when the money comes, the next day, he will simply use his votes to declare a dividend, and that money will go back to him because Paphitis owns 75% or thereabouts of the company shares. So who will make money? The lawyers. It's just the lawyers who will make money because whatever, if Theo pays back, let's say, £10 million to the company, the next day he will pass a resolution because he has majority control, right? And get a dividend. And the money comes back to him. So maybe the directors had figured that out. That, you know, so there's no point in suing this guy. Right? There's no point in suing this guy. And therefore, we do not think it would be a good use of directorial power to bring this suit. Then, so what do we then tell the poor client? We say to him, go home, lick your wounds, and no. We'll say to him that, you know, as I said to you, a lot in life is about geography, right? So thank God that your company is registered in the UK, because guess what? We do very well when it comes to minority protection. In another system, that may be the end. But here, we have the medicine for you. And that medicine is so good, right? Not sounding like Trump, you know, so beautiful, incredible, you know. The guy has a vocabulary of like 4 words, you know, it's great. So this medicine is so good, right? It always works. And what's the medicine? It is that we should tell Theo Paphitis to buy you out. Let him buy you out, right? You know, he controls the company. Tell him to make an offer for your shares so that you no longer have to be with him. We'll do this through Section 994 of the Companies Act. So under Section 994, we'll say there's minority oppression. And under Section 996, we'll say we want a remedy. And that remedy will be an appraisal right, a buyout right, where they value my shares. And you value my shares on the basis that no wrongdoing occurred. Right? So on the basis that, you know, Theo had served the company well, no wrongdoing occurred. So I get my money. And when I get my money, I say bye-bye, you know, and I'm happy. Right? And we solve that problem. You see? So then the other case here is the Lee and Lee's F farming case, which dealt with, you know, the wife. So there's this guy, he sets up a company, and the company basically, you know, has an aeroplane, and so he flies this aeroplane, you know, to look at crops and all that. Unfortunately, the aeroplane crashed, he died, and the wife is then suing for compensation, right, under the Workmen's Compensation Act in New Zealand. Basically, on the basis that he's an employee, he should be compensated. And then, you know, the argument is that, well, no, you know, he's not an employee, you know, because he owns the company. He was the only person, right? You know, think about this. When someone says to you, he owns the company, you must know that that clearly is wrong. Nobody owns a company. Right? Nobody owns a company. A company is not capable of being owned. You know, the other time I said to you that in terms of imagination, I equated the company to the imaginative prowess that led to the very idea of a deity, right? You know, and one of the great things we did was that we created this company which could never be owned by anybody. All we have are rights in the company, right? We have rights in the company, and those rights are the shares, right? So we have shares, and the shares give us rights in the company, but nobody owns the company. You own shares, not the company, right? Now, this is important. You may think I'm just being a doctrinaire or whatever. I'm not. There's an important principle here. Because the New Zealand authorities kind of saw him and the company as one, they refused to give him compensation. And the wife, who clearly, understood company law better, was saying, no, the company exists, and my husband, as pilot, was working. He was a workman for the company. And my husband has died. He should be given compensation under the statute. And this case goes all the way to the Privy Council, and the Privy Council agrees, thereby reaffirming the separate existence of the company, right? Notice, I don't call it limited liability. Too sloppy. You know why? People then say, oh, the company has limited liability. The company never has limited liability. The company's liability is unlimited. Right? It's the shareholder who has limited liability, not the company. So I say limited shareholder liability. Right? Limited shareholder liability. And here, you'll see that I try to explain it. Again, I said this at the beginning. Remember, my style when I teach is to sort of immerse you gradually in this thing. So a lot of times I kind of, throw these ideas out even before we've reached them, right? So that they can sort of ferment mentally. So by the time we get around to it, it's there. So this is what I said. Earlier I was saying, what do you think happened in 1844? In 1844, we had an act of separate legal personality, but then and Parliament put in the law that if the company was insolvent, right, then the creditors would have a right of recourse to the members, right? So if the company could not pay all its debts, the creditors of the company will have a right of recourse to the members. And then I said 10 years later, what we then did was introduce a principle of limited recourse. That's how I described it, limited recourse. And it's limited to how much you have outstanding on your shares. Say, if the company is insolvent and the company owes money, under the limited recourse principle, the liquidator simply says to me, have you paid for your shares? If the answer is no, okay, then you pay. If you've paid, then you have no liability, right? So this is what I explained here, that I said for the effect of separate legal personality, so here I'm looking, because I know people tend to mix the two. So what I've done is disentangle them, right? So I said for the effect of separate legal personality on the liability of members under company law, I said company law did not follow the path of the general law. And I refer to the 1844 Act, which introduced a right of recourse to the members. I said this was later to change with the introduction of a rule of limited recourse in 1855 as an exception to the rule of full recourse. So the position now, and you see this in the Insolvency Act, if you turn to these provisions. So the position is that limited recourse operates as an exception to the general rule of full recourse in Section 74, subsection 1 of the Insolvency Act. So in fact, I mentioned the Insolvency Act because this makes it really clear. With the Insolvency Act, the drafting of the Insolvency Act starts with full recourse, right? And then limited recourse, right? Many lawyers or students, whatever, don't go to that provision. They simply work with the Companies Act, right? And say, oh, separate legal personality, limited liability. But to really understand it, right, you need to look at that. Now, so right, so and in fact, under general law, so really, if a company were to be created under general law, so not under not by registration, right? Because, the registration thing was what made things different. So imagine there's a chartered company. Assume the Crown were to set up a company today, or Parliament, then the normal rule would be that the shareholders will not be liable, right? The only reason why we have this situation of limited liability was because the 1844 rule introduced a rule of full recourse, and then later we changed it to limited recourse. And so to make that point clear, I talked about the position on the general law. Now, the rule against Vale Pearson. So now you see, the way we've described it, we now know that it's not just Vale Pearson. We have a rule against it. Salomon is the very first case which tells us not to do it. As you said, I think you are the one who talked about agency. Don't use sneaky ways to say, oh, there's an agency, because guess what? If you go down the agency route, right, then no company will be exempt. I have a company which I use for billing for work I do, but I want to believe that that company is separate from me. But just because I own all the shares, if you go down the agency route, then I'm caught. You understand? So, and that was clarified in 1908 in the gramophone case, because in this case, the argument there was, look, this guy owns all the shares, therefore there's an agency. Case closed. And the court said no. And the very principle of gramophone Stanley, which is that 100% ownership, total control, does not mean agency. It's still with us. I want you to internalize this. So if there's anything you take away from this class today, it should be A, separate legal personality. We've got to respect it. And B, we should not undermine it by using agency simply on account of overwhelming control. Now, it doesn't mean that there cannot be an agency. If the company enters into a contract with the shareholder saying there's an agency, right, then there's an agency, if you can have a contract, right? And we see this in Adams and Cape. We see the courts here in Adams and Cape basically saying that we're not saying there can be no agency. Of course there can be agency, because with an agency you need two people, isn't it? You need two people to agree, principal, agent. So if we have clear evidence of an agency, then fine. But simple ownership on its own is not enough. And then we've talked about Petrodel and Prest. So notice here, I said, are these exceptions to the rule? Notice the question mark. And now we know the debate between Sumption and Neuberger in Petrodel, where Sumption is saying, well, I think there's a principle called Pearson Vale, but it's limited. He never tells us how it applies, though, because all the cases he discusses are cases that can be explained by other doctrines, right? So Sumption says, what Sumption does, one, he gives the whole thing a new name. He calls it evasion principle, right? So that way everybody writing textbooks will change the chapters, the evasion principle, Sumption. He goes down in history, as coming up with this new thing. And it looks really fancy, evasion, right? But, at the end of the day, we know what's going on. He's simply saying that there's this doctrine, but then he struggles to find a case where it applies. And those two cases, Jones and Lippmann, Guilford Motors and Horn, are problematic because in Guilford Motors, Jones and Lippmann is the property case, right? Where somebody enters into a contract to sell property, and then you want to defeat the right of specific performance vested in your counterparty. So how do you do it? Because you don't want to be subject to a decree of specific performance forcing you to convey the property to him. So what do? You convey the property to a company, right? And the courts basically, the way they described it then was to say, oh, yeah, we pierced the veil. We looked at all of them, we pierced the veil, but today we say we can explain it differently, right? In the case of Guilford Motors and Horn, it has to do with a clause in the contract about non-competition. right? So you work for the company, so we say, okay, if you leave, don't compete with the company. So what does he do? He forms a company to compete. And he says, it's not me competing, it's not me competing with the company, and all that, right? The courts, again, find ways around that, right? So by the time we get to Adams and Cape, which I believe will be discussed fuller in your tutorials, but by the time we get to Adams and Cape, you see the Court of Appeal. So, I mean, the background to Adams and Cape is that, by 1967, we have Lord Denning in the courts, molding this area. And for those of you who know Lord Denning, he's always wanting to do justice. That's not to say the other judges don't do justice. But he's always very keenly involved in this quest for justice and trying to cut through technical rules. And he says, in a case called Littlewoods in the IRC, that, we should be able to pierce the veil easily to know what goes on and do justice. And he says, look, Parliament has shown the way with group accounts. Parliament has shown the way with group accounts. Now we consolidate accounts between parent and subsidiaries. The courts should follow suit, right? So he's saying that the courts should follow what Parliament does, and we should be able to pierce the veil, right? So that's Littlewoods. So that changes the way we see things, right? Because remember, before Littlewoods, you had Gramophone and Stanley, which is let's respect. By the time we get to Littlewoods, things are changing, and that change continues. And then you get to a case called DHN. Now, these cases are not on your list because they're all discussed in Adams and Cape. If you read Adams and Cape, you'll see the cases there, and certainly Petrodel, but Adams and Cape. And I always think if you have one, you can discuss those. Now, so by the time we get to DHN, again, Lord Denning is on the court, and Lord Denning says, you know what, we can lift the veil, we can pierce the veil, and he comes up with this idea that, if there's a parent and subsidiaries, we should say a single economic entity, a single economic unit, right? Now, by this time, people are worried. The courts are worried because they're thinking, the UK is, a financial capital, right? The city relies on structures being observed. So if a judge can unravel these arrangements simply on the basis of a single economic entity, then so many things. This will affect so many things. So immediately, the House of Lords, in a case called Wolfson and Strathclyde, decided on facts very similar to the DHN case, says, well, we think Denning was mistaken. We think that the better way to decide DHN was simply to look at the facts of the case and look at the precise agreements reached. Yes, would have reached the same decision he reached, but for a different reason, right? And they then say, you know what, we need to respect separate legal personality, right? So in other words, the Denning wind, which is sort of messing up the law, was now sort of leaving, right? So with Wolfson and Strathclyde. And then comes the Court of Appeal in Adams and Cape. So Adams and Cape now clarifies the law. And this is why I say, by the time you deal with Adams and Cape in your tutorials and just go through it, if you've not read it, please do read it. You then see the law really being clarified, which essentially is about respecting separate legal personality. And the last assault, main assault, was Petrodel. And again, you see the Supreme Court basically saying, no, no, no. As I speak to you now, there's a case in court on the tort principle, right? Because, the AAA case, which I mentioned, which deals with tort, I think I mentioned that here. So, so here we're dealing with the tort. So, I said in recent years there has been an increasing tendency for claimants to sue English parents in respect of alleged torts of subsidiaries abroad, right? And the Court of Appeal held that a parent will only be found liable, as in subject to a duty of care, in relation to the activities of a subsidiary if ordinary general principles of tort apply in regard to the imposition of a duty of care. And he says, the court basically says that, there are two broad categories of cases. The first is where the parent company, had in substance taken over the management of the activity of the subsidiary in place of the overseas management, right? So when you get the management here, literally telling the guys downstairs how to do things, then we would say that in tort law, the parent company owes a duty of care to whoever is there, right? And then the second one would be those cases where the parent company had given relevant advice to the subsidiary about how it should manage particular risk. In the AAA case, the claimants relied on the B head, and it failed, right? They couldn't sustain that. So, so essentially, that's it. You will see, just one last thing to end. You have all the statutory provisions. You know, I say the so-called statutory lifting of the veil, I qualify, it's not really a lifting of the veil. It's not even a piercing. It's simply situations where statute says some people should be liable. So take directors. If directors are guilty of wrongful trading, right? Again, you'll talk about this in your tutorials. Well, if directors are guilty of wrongful trading, then they would be liable. But I don't call it veil piercing because directors did not even have limited liability in the first place, right? A director is not a shareholder. Does not need to be a shareholder. So if I'm a director, I don't have limited liability in the first place, right? I'm not liable for the company's debt. So if under Section 214 of the Insolvency Act, wrongful trading, I am to be regarded as liable, right, to pay money, it is because by statute, I have been told to compensate a victim of my actions, right? And that would be in cases of what we call wrongful trading, right? So I will end on this note. And, thank you.
So it's just like, if it's black, just tap on the screen and then just make sure PC is selected. Yeah. And then if it's still off, just
I would just press this to check like in terms of
Okay. Alright, so that all seems quite straightforward. It's black, just touch it to make sure that PC is on and that the screen has the one. And now it should be pretty straightforward. Oh, great. Okay, that all seems to be working and up and running. Guys, you're amazing. I wish this was my...
familiar with it.
So this is the lecture capture. So yeah, I've consented to the first 4 lecture captures, and that's off then after, was it next week? After next week? There's 4 of them.
Yeah,
Yeah.
I'll make sure.
That's brilliant.
But
Thank
like,
you.
if you push it down, it will close it.
Oh, I didn't know that. Well, it's just, I have to say, as a lecturer, I do get quite nervous about like some of the commentary and discussion you have in class. And